a fixed place of business, or as tax junkies call it, a permanent establishment, has been a much contested issue between taxpayers and revenue. A Delhi High Court ruling last week in the case of US headquartered e-funds brings in much needed clarity on what constitutes a permanent establishment in India. Now, this is good news for the outsourcing industry. Paiswini Upadhyay reports on the top 3 takeaways from that ruling and their impact.
Over the years, global advisory firms have ranked India as the top destination for outsourcing business. Most of the success can be attributed to the IT and IT-enabled services and contract manufacturing outsourced to India by foreign companies.
The foreign company which outsources to India can either set up its own subsidiary and then use that subsidiary to do all the work which has been outsourced to it. It is something which is used by some of the very, very large financial services companies, where also confidentiality and control on confidentiality, etc., are very, very major concerns. Or it can also be that the foreign companies use third-party service providers for the purposes of outsourcing, the likes of Genpact, Infosys, Wipro, Satyam, Mahindra BT, etc., etc.
This categorization is critical in the context of rate of taxation. An Indian company carrying out outsourcing activities for a foreign company is taxed at the usual corporate tax rate of 30% plus surcharge. But if the foreign company has an economic nexus that creates a permanent establishment, the rate of taxation is 40% plus surcharge. And whether a PE exists or not is determined by tax treaties. Though highly litigated, the concept of permanent establishment has very limited clear jurisprudence. One such is the Apex Court's landmark ruling of 2007 in Morgan Stanley's case that dealt with the concept of a location and service PE. The Apex Court had ruled that stewardship activities such as risk mitigation, quality control will not result in a permanent establishment, but deputation of personnel by the foreign company will give rise to a PE.
The law evolved thereafter, and all kinds of complex business models did come up. More importantly, the revenues focus moved beyond the dependent agency principle. The revenues focus was what happens if there are employees from the foreign enterprise who are present in India. What happens in a situation where those employees are working out of a premises which are under the control of the foreign enterprise. What happens in those situations? Does it constitute a permanent establishment? What is the degree of permanence of stay of those foreign enterprises employees, and under what circumstances will they constitute a permanent establishment?
It is for this reason that the Delhi High Court's ruling last week in US headquartered e-funds case assumes importance. For the first time, the Delhi High Court has laid down a clear jurisprudence on 3 important aspects of PE determination. 1. Whether a subsidiary can be a permanent establishment. 2. When is a service PE constituted? And 3. The impact of mutual agreement procedure on PE.
The first issue examined by the Delhi High Court was, when can a subsidiary be a permanent establishment? The court concluded that if the subsidiary's premises are at the disposal of the parent and is used to carry out the business of the parent, it would give rise to a permanent establishment. In addition, if a subsidiary has the authority to conclude contracts in the name of its parent and this authority is habitually exercised, it would constitute a permanent establishment.
What the court has said is there are 2 separate legal entities, taxpayers of 2 separate jurisdictions, and that legal sanctity, legal segregation of entities needs to be respected. It doesn't mean that the other provisions of permanent establishment should not be examined, but just because a subsidiary is 100% controlled by a foreign company, it does not mean that the subsidiary's premises are at the disposal of the foreign company and therefore the permanent establishment of the foreign company. Not only that, what is the business that is being carried out by the Indian company? Is it carrying out the parent company's business, or is it carrying out its own business? If it's carrying out its own business from its own premises, again, you cannot use the fact that the parent company controls the Indian company. That makes it that it is carrying out the business of the foreign company in India.
The second aspect dwelled upon by the High Court related to constitution of a service PE. India's tax treaty says a service PE exists if the foreign company provides services in India through its employees or other personnel. The Delhi High Court has interpreted that to mean that the employees or personnel must be engaged and appointed by the foreign company, and that the employees of the Indian entity cannot be treated as employees of the parent.
For any subsidiary that's operating in India, obviously the employees of those subsidiary will work under some degree of supervision of the headquarters or of the foreign enterprise. Now, there was a kind of debate in the minds of people whether that would constitute that those employees who are based in India, employed by the Indian company, just because they get some degree of direction and supervision from the foreign enterprise, would they be considered as a dependent agent and hence constitute a PE for the foreign enterprise? Clearly that interpretation is misconstrued, and that's not the correct interpretation. That is something that the Delhi High Court now seems to have put to rest by saying that these employees who otherwise would constitute a dependent agent has to be first employed by the foreign company.
The third important aspect ruled upon by the Delhi High Court relates to the relevance of Mutual Agreement Procedure or MAP, a dispute resolution process used by companies to avoid double taxation. The High Court held that if a taxpayer has agreed to existence of a PE under MAP for a given assessment year, that agreement would not be binding on the taxpayer for the following years.
There are two issues on which the court has given this ruling. One, it says that existence or otherwise of a PE is a question of law and fact both. A principle of law cannot be given up by a compromise, and a mutual agreement procedure is a compromise between the taxpayer and the revenue. So they following from this issue, they have held that in a subsequent year the taxpayer would be at liberty to raise that principle of law. Then they have also pointed out that the order of MAP in the relevant year itself said that it will apply only to these years and not to succeeding years. So, in my opinion, the court has followed the right principle to arrive at this position.
There have been many tribunal and AAR rulings on what constitutes a permanent establishment. Just last year, Convergence lost before the Delhi ITAT that looked at the functions, assets and risks of the Indian subsidiary and held it to be a PE of the parent. The tribunal, experts say, failed to consider the criteria for constitution of a PE, which the Delhi High Court has now articulated. While all the guests in the story lauded the detail in which the Delhi High Court has explained the constitution of a PE and the clear jurisprudence that this order provides, they also cautioned against its blanket application, saying the department is likely to distinguish cases on specific facts. But surely, the legal principles laid down by the Delhi High Court will provide weight to taxpayers' arguments in all future cases. In Mumbai, by Swini Upadhyay.
All right, there you have it. More clarity on PE. On that note, let's take a quick break on the film. When we come back, dear MNCs, get ready for country by country tax reporting.